Hi, I'm Alex Kennedy. I'm a disputes and employment solicitor here at Gannon's, and today I'm going to talk to you about restrictive covenants, and in particular what to do if you're accused of breaching restrictive covenants, or if you have an employee who you suspect has breached their restrictive covenants. A restrictive covenant is a promise not to do something. In an employment context, they are usually intended to prevent outgoing employees from competing with their former employer by working for a competitor, setting up their own company in competition, or by poaching customers, clients, suppliers, or other employees. As a matter of public policy, the courts don't like parties entering into agreements which prevent someone from working. Therefore, a court will simply refuse to enforce a restrictive covenant unless the former employer can show that the restrictions A, protect some legitimate interest, such as the goodwill of the business, trade secrets, confidential information, or the stability of the employer's workforce, and B, that the restriction goes no further than is necessary to protect that interest. In practice, this means that restrictive covenants must be time-limited. Typically, restrictions will last no longer than 3 or 6 months, although restrictions of up to 12 months are possible. And the restrictions will also need to be very carefully drafted to be no wider than is necessary. So, for instance, it's not unusual for a restriction to specify that an employee is only restricted from doing the exact job that they did for their former employer, or they are only restricted from working within a particular geographical area. We often have clients who are either seeking to enforce covenants or are seeking to escape from them. They are a very common flashpoint for litigation. Employers who are seeking to enforce a restriction are typically seeking an interim injunction. They want the court to make an order that prevents the employee from taking up a new job, from working for someone else, from starting a new company, or from poaching staff. The nature of interim injunctions are that they are quick and expensive. It's possible for an injunction to be obtained within a matter of weeks rather than months or years, but the flip side of that is because counsel need to be appointed very quickly, a lot of work needs to be done very quickly, they can be very expensive. And so all sides need to be aware of this if they are considering any sort of litigation around restrictive covenants. While they are commonly found in an employment context, restrictive covenants can be found in other documents. So, for instance, if you purchase a business or you purchase shares in a business, it's very common for the share purchase agreement to include a restrictive covenant. A shareholders' agreement would also usually contain restrictive covenants. After all, if you invest in a company or buy a company, you do not want the founder of that company immediately going off and opening up in competition against you. One of the reasons the courts are reluctant to enforce restrictive covenants in an employment context is because of the inherent inequity that exists between an employer and an employee. Usually, employer and employee do not have equal bargaining power. The employer can be a multinational company with virtually unlimited resources for negotiation and litigation, whereas the employee is the little guy. However, those same considerations don't apply in the context of restrictive covenants in other documents, such as shareholders' agreements. Therefore, the courts are more likely to allow longer and broader restrictions in a shareholders' agreement or in a share purchase agreement or a franchise agreement, for instance. However, that doesn't mean that restrictive covenants in these documents are beyond challenge. And if you have any concerns about restrictive covenants, either enforcing them or escaping from them, we'd be very happy to help. I hope that was useful. As I said, restrictive covenants are a bit of a minefield and a real magnet for litigation, so I'm sure you may have questions, and if you do, please do get in touch.